Welcome to Background Checks Under Fire, Policy Considerations to Avoid Discrimination Claims. I'm Mike Coffey, President of Imperative Information Group. Imperative is a background screening company based in Fort Worth. I'm an HR guy. I've been in and around HR for now over 20 years, and I'm a senior professional in HR, certified by HRCI. And I was the 2013 president of the Fort Worth Human Resource Management Association, the best little SHRM chapter in Texas. And I sit on the board of the Texas Association of Business. This program is one of an ongoing series of webinars we do for our clients and our friends in the HR community, focused on compliance in the area of using employment background checks and how to use employment background checks to ensure that you've got a safe and productive workplace. Imperative has been selling background checks for 15 years, and that's, when I started the company 15 years ago, that was our primary focus. I also do some HR consulting for our clients, and a lot of that is free consulting where they call me and say, help, what would you do in this situation? And we spend some time noodling on those kinds of issues. All of that said, I'm not a lawyer, and I'm especially not your lawyer. So make sure that whatever you do, you take what we tell you, and maybe go talk to your own employment law counsel. They may not agree with what I say, and if they don't, you can always go find another lawyer. They're a dime a dozen. But make sure that whatever you take away from our presentation today and the notes that you get later, you do bounce off your employment counsel, because as we'll talk about later in the webinar, there are a variety of state laws that we're really not going to get into today that would impact your use of background checks depending on where you're operating in the country. And I want to make sure that we keep you out of trouble. But at the same time, you're going to hear a fair amount of what I call the gospel according to Coffey. This is just practical advice, things that we've figured out as we've worked with clients dealing with these kinds of issues over the last 15 years. And some of them are very much focused on compliance in the background screening area, while others are focused on, maybe not doing necessarily what the EEOC wants you to do, and we'll get into some of that as well. There are times where you have to say what this agency wants me to do may not make sense in your environment, and we'll talk about some of those as well. So recognize when I'm talking about what the law says, I'm being very literal, and that's what the law does say, but there are going to be times where I say, and here's what I would suggest, and that's strictly Mike Coffey's opinion, not your legal counsel's opinion. So take all of that with, keep that in mind as we go through the webinar today. Whenever we start talking about background checks, especially in the legal compliance area, I think it's always important that we start by reminding ourselves why we even run background checks. Why do employers care about these issues? And the fact is that a lot of people in the media, some community action groups, and unfortunately some regulators seem to have the idea that employers are just being nosy, that they just want to play gotcha with employers or with prospective employees. And we all know that's not the case. What we want to do is have as much information as we can about our prospective employees to make an informed hiring decision. I don't know any employers who want to do anything illegal, or certainly none of our clients have ever expressed the desire to discriminate against anybody based on any protected class, or even just to be mean. I mean, it's just not what, employers are trying to find the best qualified people for each position and evaluate all their candidates fairly. And part of that means that they're looking at their background, at the backgrounds of these candidates. Employers do background checks to ensure that their people in their own workplace are safe, that they're not introducing elements into the workplace that would pose a threat. They want to protect the public, so they want to make sure that they're not sending employees out to deal with the public, whether it's on, out in, on the open road or in a customer service role in a retail store or anywhere else where that person might pose a risk to the public in the course of their duties. And of course, the employer's reputation is always an issue as well. The employer may not be at fault in a negligent hiring sense, ultimately, for the actions of an employee, but at the same time, that really doesn't matter if the employer's reputation has been tarnished because some knucklehead employee did something stupid along the way. So knowing how these employees have acted both professionally and in their personal lives to a certain extent gives employers insight into how to evaluate what they may do in the future in the employment context. We have a whole website out there called badhiredays.com, and it's full of stories about real people with criminal histories and the employers who hired them not being aware of those criminal histories and what they did to those employers and those employers' customers. And we also talk about on that website how employers can avoid those kinds of mistakes. And in fact, we're going to be publishing one later on this afternoon about the Delta sorority. They just lost $400,000 in tri-delt jewelry to somebody who had, I think, 7 theft by checks, 2 felony convictions for fraudulent access of controlled substances, and 2 felony forgery cases. This is not somebody you want to give access to your office space, and but there it is, and $400,000 later, the tri-delts are wishing they probably had done a better background check. So you can go to badhiredays.com to see those. So let's jump right into Title VII of the Civil Rights Act. Title VII is the part of the Civil Rights Act that protects individuals from discrimination in the employment context based on their race, color, sex, national origin, and religion. President Johnson signed the Civil Rights Act in 1964, and President Bush signed amendments to the Civil Rights Act in 1991. Of course, there are other laws such as the ADA, ADEA, GINA that also create protections for certain individuals in the employment context. But today we're really talking about the Civil Rights Act and the EEOC, which was an agency that was created by the Civil Rights Act and is charged with enforcing the Civil Rights Act. Now, what's really important, and I really want to stress here, and you'll hear me say it throughout the webinar, the EEOC is not a regulatory agency in the sense that the Department of Transportation is. For instance, if any of you are DOT-covered employers, you know the DOT publishes regulations. They put them out to the Federal Register for public, and they go to public comment, and then they're finally published. And once they're published, they're as good as law as far as employers that are governed by them, by the DOT regs, are concerned. The EEOC is a different kind of animal. They're a law enforcement agency. They are like your local police department. Their job is to enforce the law, but they do not have the ability of judge and jury to determine whether an employer has truly violated the Civil Rights Act in 1964, Title VII. And that's important because they publish a lot of guidance and they make a lot of claims, but it is strictly those claims are strictly the opinions of EEOC staff and attorneys. And now, they should be paid attention to. I'm not saying you should ignore them any more than you should ignore any other legal expert. But you have to there are times where you're going to make business decisions and review your own company's position with regard to some of these issues and say, we don't think the EEOC is right here. And quite honestly, in the last few years, they've made it a lot easier for employers to disagree with them because they've taken some pretty outlandish positions. So we'll get into some of those. There are 5 commissioners on the EEOC. Currently, there are 3 Democrats and 2 Republicans. The Democrats are typically very pro-labor appointees, and the Republicans are typically very pro-management, pro-employer. You can see the bio of their most recent commissioner appointment, Jenny Yang, and this is directly from her plaintiff's law firm bio. She represents employees nationwide in complex civil rights, class actions, and wage and hour collective actions. So she's definitely a pro-employee and pro-labor commissioner. And a lot of these commissioners are folks who are very hardworking and reasonable people in many contexts, but their longer term, where their opinions that they've published and some of the positions they've taken have have not necessarily been supported by the courts over the last few years, and so we'll get into some of those. And I should also say that I don't mean to take disparage plaintiffs' lawyers. That they definitely have an important place in righting wrongs, and I would much rather see plaintiffs' lawyers representing employees' grievances than government agencies in many cases. So there's other routes for Title VII enforcement besides going to the EEOC. A state fair employment practice agency is a state-level organization that can enforce in that state Title VII violations, and all but 2 states have those. And then there are also the ability for individuals to file lawsuits after they get their right to sue letter from the EEOC. So let's get into some basic concepts. Disparate treatment is the concept under Title VII. This is the original idea behind Title VII, was that we are going to prohibit discrimination in employment against people simply because they happen to belong to a certain class. And typically, this is played out in most people's experience with race, gender, national origin, those kinds of issues. And we know that when we see it. We know disparate treatment. It's right there in a company policy or in an employer's obvious practice. Those are obviously things that we recognize, and they're wrong and they should go away. And most of us see that, understand that, and there's really, I'm convinced, not a lot of that direct disparate treatment going on anymore. A few years after the Civil Rights Act was passed, Griggs v. Duke Power was published, and that case created a new kind of discrimination law called disparate impact, a new theory. And basically, disparate impact occurs when a company has seemingly neutral policies or practices that on their face don't seem to be discriminatory. You've got to have a high school diploma for this job. You've got, maybe you've got to be able to lift 100 pounds to perform this job. Policies that on their face don't seem to be intended to be discriminatory. But in their implementation, they do adversely impact people in a protected class. And in the Duke Power case, what happened was Duke Power created a policy that all supervisors have a high school diploma and that they pass an IQ test. This case was 1971 when the decision came down, so we're talking about actions Duke Power took in the 60s. Now the 60s in the South were, were just coming after some of the most turbulent times of the civil rights movement. And so clearly there were large populations of disenfranchised African Americans who hadn't had the opportunity to complete school, and certainly not the opportunities that their white counterparts had to have that high school diploma or even have the level of education that would give them the ability to compete on an IQ test. And so they weren't, because of that, they weren't able to become supervisors at Duke Power. Well, a group of them took Duke Power to court. In that case, found its way all the way to the Supreme Court. And in 1971, the Supreme Court came back and said, they agreed with the plaintiffs that this was a new kind of discrimination called disparate impact. You've got a policy that on its face seems neutral, but its implementation impacts a protected class, and there's not a bona fide business necessity for that policy. In the Duke Power case, what happened was that the plaintiffs demonstrated that there were supervisors for Duke Power who had been supervisors before they implemented this policy and who did not have their high school diploma, but their performance reviews and all the records showed that the high school diploma was not an indicator of success, and that these folks who did have high school diplomas or did not have these high school diplomas were no more likely to be weaker managers than those who did have high school diplomas. So this bona fide, there wasn't a, Duke Power could not point to a bona fide business reason for having this requirement, and because this requirement did impact individuals in a protected class, then they were, the court found that they were discriminating. And Justice Berger, in the Griggs decision, even said, good intentions don't do you any good here. Even if you have good intentions or you've got an absence of bad intentions, you don't intend to discriminate, that doesn't redeem a policy that in effect, once it's placed into effect, proves to be discriminatory. And so even though Duke Power had programs in place to help their employees, including their black employees, obtain the right, the necessary education levels and all of that, become supervisors, that didn't redeem the fact that the outcome of the policy was that those people were discriminated against. We get more on point with Green versus Missouri Pacific in 1975, because this is a case that deals directly with an employer's use of criminal records. And again, this is a disparate impact case. Missouri Pacific Railroad, MOPAC, had a policy that said they would not hire individuals who had any criminal history, period. They had what was called a bright line rule. It was, you couldn't have any criminal history, period, to come work for MOPAC. Well, again, there was a group of plaintiffs who brought a case and pointed out that, in fact, minorities and I think in this case it was on a nationwide basis, were arrested, prosecuted, and convicted at a higher rate than the general public. So that fact, and the fact that many of these offenses that people were being disqualified for, and in the Griggs case, I think Mr. Griggs' offense was draft dodging, and he had served some jail time for avoiding being drafted into the Vietnam War. How does that affect his ability to work at a railroad? And that's basically the question the court asked, because they found that the policy did discriminate against minorities. And so they came out in the Griggs decision with, and not just 3 bullet points like this, you have to read the whole decision and kind of ferret this information out, but they came out with really what are called the green factors, kind of suggestions that employers ought to look at the nature of the offense, how long ago it was, and how much time's passed, and the nature of the job, and how those things are related. So how does this offense and what's the severity of the offense, and how does it relate to the job? How long ago was it? And then the EEOC has opined over the years that even employers can consider non-conviction information, dismissed cases. They just have to, it has to be reasonable for an employer to believe the person engaged in the underlying conduct. And we'll talk about that a little bit later as well. So what you don't want to do is have a criminal bright line rule that just automatically wipes out a large crop of your employment applicants, because you're very likely to impact a protected class by doing that. In many communities, it's probably still statistically correct to say that minorities are arrested, prosecuted, and convicted at a higher rate than the white population. So you don't want to do this. And most employers don't do that, but what we do see are things like this. Clean background check required, no felonies allowed, no convictions for theft or dishonesty. These kind of qualifications or disqualifications do tend to be still probably, in many cases, overly broad. Clean background check required. What are you telling your applicant there? If you've got something negative on your background, don't apply, which is pretty much a bright line rule. No felonies allowed, and this is the one when I make presentations to SHRM chapters that they a lot of people's eyebrows jump up, because a lot of them, I think, may have policies like this, at least for some of their positions. But what you got to remember with felonies is what's a felony in one state is a misdemeanor in another state. There's not a ton of uniformity for what's a felony or misdemeanor state to state. Also, like here in Texas, your third DWI is a felony. So how does that, the fact that somebody maybe got their third DWI 10 years ago, haven't had any other legal issues in the last 10 years, how does that affect their ability to do a job in an office environment where they don't ever drive or operate any dangerous equipment? Probably doesn't. But by saying no felonies allowed, you're eliminating people, and without a good business reason often for the reason for the elimination. Likewise, no convictions for theft or dishonesty. And this is, sounds obvious. Well, we don't want to hire anybody who's dishonest or who's a thief. But again, if you get a 35-year-old applicant who walks in the door and their only criminal history is a 15-year-old or 17-year-old case for shoplifting when they were maybe 18 years old, that's theft. And are you really going to, disqualify a candidate, who has an old shoplifting case, especially when they're open and honest with you about it? That's just, that's probably not very predictive of their performance in your environment. And the EEOC has been very focused on these issues, looking for cases where employers have policies in place that aren't on their face discriminatory, but in their execution, they have a disparate impact on people in protected classes. And what we've seen there is things like Pepsi-Cola. They, after an investigation in January of 2012, PepsiCo Beverages entered into a conciliation agreement with the EEOC for $3.13 million based on allegations that Pepsi discriminated against African-American applicants based on their use of criminal history in the hiring process. Now, let's think about this, though. Pepsi is a giant company, okay? $3.13 million is probably Saturday morning advertising costs for somebody like Pepsi. I mean, it's a significant number, especially for a company like mine or yours, but $3.13 million is not that much for Pepsi. And, you've got to wonder, did Pepsi settle this because EEOC litigation is very expensive? Or did they actually think they've got a problem? I think if the EEOC, given all of their other history, I think if the EEOC thought that they really had a really strong case against Pepsi, you wouldn't, and they could get more than $3.13 million out of it, they would have pushed this case a lot harder and a lot farther. The EEOC sued Freeman companies based over in Dallas, or in our little suburb from Fort Worth. In 2009, they filed a discrimination lawsuit against Freeman for rejecting job applicants based on their credit history and if they had one or more various types of criminal charges or convictions. The EEOC was claiming that Freeman's use of criminal history was adversely impacting people in a protected class. Ultimately, the case boiled down to the EEOC's ability to prove statistically that that Freeman was actually discriminating against applicants based on that information, and ultimately they couldn't prove it. Freeman had a fairly robust criminal history records policy that tied specific offenses to particular kinds of jobs. And there's a lot in the notes on this slide for you to read about if you really want to get down into the weeds on it. But it was the judge in that case wrote when he dismissed the case, found for Freeman, said that the EEOC has made no effort to break down what is clearly a multifaceted, multi-step policy. And though it is theoretically possible that one or more defendants' background check considerations causes a disparate impact on certain classes, the EEOC has failed to demonstrate which such factor is the alleged culprit. So accordingly, the EEOC has failed to establish that discrimination actually took place. You got to remember that these cases are statistics cases. You've got to prove a disparate impact, and they've got to do that statistically, and that's been very difficult for the EEOC to do and convince a court. And the EEOC also, according to the judge, their case was a plethora of errors and analytical fallacies. Made the EEOC's experts' conclusions completely unreliable. So the EEOC is not necessarily a fair fighter in these lawsuits, and I don't think they care that they lose. Really, their intent is to change public policy and how employers view and use criminal history information. And in fact, and this is gospel according to Coffey stuff, but I think they're accomplishing what they want, even though they're losing the lawsuits, because I'm talking to a lot of employers who are being a lot more cautious and maybe overly cautious in the use of criminal history. KAPLAN Higher Education was another lawsuit the EEOC brought, and it was ultimately decided in favor of KAPLAN. And in fact, the EEOC's own use of credit history was used against them in court, because they found that the EEOC's rationale for using credit in its hiring practices was very similar to KAPLAN's. And then there's the PEOPLEMARK case. PEOPLEMARK is a staffing company in the Northeast, and the EEOC conducted a 3-year investigation into claims filed by a woman named Sherry Scott. She is a 2-time felon with convictions for housebreaking and larceny. Now, PEOPLEMARK chose not to hire her because of her criminal record. They're a staffing agency. Now they're going to send somebody with felony convictions for theft into their clients' workplaces. That's what I would want from my staffing company. Do not send me those kind of people. Thank you. Ultimately, after 3 years of investigation, the EEOC filed suit in 2008 claiming that PEOPLEMARK had a blanket policy of not hiring former offenders. PEOPLEMARK was forced to provide 18,000 pages of documents with detailed personnel information. After a year after filing the suit, the EEOC finally identified the 286 people who composed the class in the suit. So they had identified 286 people who were going to be their their plaintiffs against PEOPLEMARK, people who were claiming they were discriminated against based on their criminal history. And PEOPLEMARK gets this list of 286 people, analyzes it, and says, hey, wait a minute, we hired 22% of these people. So not, they can't say we treated them unfairly. They were hired. And ultimately, the EEOC continued to litigate that case anyway. And the case dragged on, and ultimately, the EEOC could not find an expert who could testify that the statistical disparate impact was occurring because of these criminal history records, because it seems very clear they weren't. And ultimately, the case was dismissed when the EEOC failed to designate their expert. So PEOPLEMARK said, well, good, we won, but we just spent $750,000 defending this suit, $751,942 in lawyer fees and expert fees. They went back to the court and convinced the court that, hey, the EEOC should have to pay this. In this case, loser pays. And the court agreed. And so the EEOC had to pay PEOPLEMARK $750,000 plus. And at first we all say, yay! And then we realize, wait a minute, those are tax dollars. We paid that. And no, darn. So the $750,000 is it's a blow for justice, but it's also a blow out of our own pockets. Then they filed two cases last year, one against BMW, about BMW's use of background checks when hiring contractors, when they've got an agency that provides contract labor for them, and the EEOC is saying, well, this agency was using BMW's policy for the use of criminal history, so BMW is on the hook for any discrimination. And there's a full write-up on our website, and in the notes we'll send you about the BMW case. They also filed suit against Dollar General, saying that Dollar General's use of criminal history information resulted in, quote, ongoing nationwide race discrimination against black applicants in violation of Title VII. And to be honest, looking just through the EEOC's pleadings, and we'll see what comes out when Dollar General's story gets out, but doesn't look good for Dollar General just based on what the EEOC says. But of course, they're the plaintiffs. They get to lay their case out first, and they always lay their case out in a way that makes it look bad for the other guys. So again, on our website and in the notes we'll send you, there's a full write-up on the Dollar General case as well. So here's the big question. How many disparate impact cases related to employers' use of criminal history have plaintiffs won since 1975 with the the Green versus Missouri Pacific case? None. There have been no disparate impact cases that have gone to court and gone all the way to judgment that a plaintiff, whether it's EEOC or a plaintiff's attorney, has won. So why are we talking about this so much? Why are we spending so much time about it? Well, the EEOC has made it a front burner issue for the last several years, and I think there's a lot of credibility that automatically goes to the EEOC in the public's view, if not the court's view. Now, if you're a government contractor and you're governed by the OFCCP, you need to know that the OFCCP in January of last year issued Directive number 306. And basically what they do in Directive 306 is adopt the EEOC's guidance on the use of criminal history records. And the OFCCP has a lot sharper teeth when dealing with government contractors than the EEOC does with non-governmental contractors. And so you need to be, if you're an OFCCP covered employer, you need to pay a lot more attention probably to some of the issues we're going to talk about here in the second half of the webinar. You should also know that there are state EEOC laws, EEO laws that have job-related requirements, or those green factors, and they govern how employers use criminal history or other factors in making decisions, and they have to be job-related. When it's criminal records, they need to follow the green factors. And then there are, at municipal levels, there are also some of those kinds of laws. A number of states have limitations on employers' use of credit reports. I think there are at least 10 of them right now that have limitations on how employers use credit reports. Some are pretty loose. They just say it's got to be job-related, and others are really strict and very narrow provisions for the use of credit in the making employment decisions. And to be honest, I spend more time talking employers out of trying to use credit in making employment decisions because they don't tell you the story you think they're going to tell you. I talk to employers all the time who say we want to run credit reports because our people handle a lot of cash, and somebody who's got bad credit is more likely to steal from us. Well, the truth is that the studies that are out there, and there are not a lot of them, but the studies that are out there suggest there is no correlation between bad credit history and job performance or honesty or integrity. Employees, even in the financial services area, with negative credit histories were no more likely to steal from the employer or to be in progressive discipline or to terminate voluntarily or involuntarily employment than employees with positive credit history. So the only time we ever recommend it imperative that employers look at credit history is when the individual will be making financial decisions on behalf of the company or clients. And if you're going to try to draw some correlation between how they manage their own personal finances and their own personal business and how they'll manage the company or customer's business, that's the only time we really ever recommend employers look at credit. And there is a national movement to ban the box. That's the idea that employers should remove the criminal history inquiry from the employment application. And more places are doing that. San Francisco just passed an ordinance, and we've got a blog write-up about it just last month, disallowing employers from making criminal history inquiries on their employment application. And in many cases, these prohibitions prohibit employers from asking about applicants' criminal histories until after they've done an interview, which is the case in San Francisco as well. This is a bad idea, but I'm afraid this is a tide that we're not going to turn. But we'll talk about it a little bit more later. So let's get into the EEOC guidance. We've got about 20 minutes left and about an hour of stuff to talk about still. On April 25th of 2012, the EEOC published a new guidance on employers' use of criminal history. And there's some good stuff in there, and there's some bad stuff. I'll tell you the truth, it's a really good primer on the history of disparate impact law. There's some great citations there. There's pages and pages of end notes and footnotes, and they're very helpful. The problem is sometimes when you read the footnotes and read the things that they're citing to support their arguments, you wonder, how did they ever make this argument based on this information? There are things that the EEOC just seems to put in their footnotes, and even though it is complete opposite of what they're saying in their argument. There's been a lot of reaction to this new guidance. The attorneys general for 9 states sent the EEOC chair a letter challenging the new guidance, and then last November, the Texas Attorney General filed a lawsuit against the EEOC seeking an injunction from the EEOC enforcing their guidance against the state of Texas. So it's going to be litigated for a while, and we'll see what happens. But the real issue is, how do we keep you as employers out of the crossfire between these warring factions? First thing to realize is that the law has not changed. A lot of employers I hear from all the time say, well, yeah, tell me about this new EEOC law, or tell me about how those, the law has changed regarding what employers can do with criminal background checks. On the federal level, the law hasn't changed. Title VII has not changed. There's no new court cases that suggest that anything has changed. The only thing that's changed is how the EEOC is trying to enforce Title VII. So there's the big news, and it's the most important thing you need to take away today is the last time the Title VII was really changed in this area was in 1991, and that was just codifying the legislative history from Griggs v. Duke Power. So why did they write this new guidance? Well, they wrote it, and what you're going to see here on in are some pretty boring screen prints because I wanted to show you exactly what the EEOC says in the guidance. They say this guidance is to be used by employers, by individuals who suspect they've been denied jobs or promotions or been treated unfairly based on their criminal history, to see if they think they've got been treated discriminatorily, and by EEOC staff who are investigating discrimination charges. There's one group that they failed to mention here, and that's, again, plaintiffs' attorneys. And I think this is really a roadmap to litigation for plaintiffs' attorneys and corporate counsel defense attorneys. This is going to end up, if it's continued to be, if they continue to pursue it like they have, with either private counsel or the EEOC before the Supreme Court on these issues. So the EEOC does, I think, begrudgingly admit in their document that having a criminal record is not listed as a protected class in Title VII, but they do go into the idea of disparate impact and disparate treatment, and they spend a lot of information, a lot of time going through the history of disparate impact law. And they get into the green factors, which are those factors from Green versus Missouri Pacific, the nature of the offense, the time that's elapsed, and the nature of the job and how those things relate. And they do a really interesting job going through each of those. But then they add this thing that's a new concept called individualized assessment. So first they go through each of the green factors, the nature and gravity of the offense, and it's pretty straightforward. You look at the, what the person, what conduct the individual engaged in and how serious was it, then the time that's passed, how long ago was it, and they really want to look at things like recidivism, declines over time, and things like that. The studies suggest that, again, they're very undefinitive, and they're very small scope studies, but they tend to suggest that people who have not committed new offenses in more than 10 years are significantly less likely than people who've committed more recent offenses to perform new offenses, to commit new offenses. And that's a big issue, is recidivism, because if there was a way for you just to simply know as an employer, this person is completely rehabilitated, he's not going to commit any more offenses against the public or the employer, then you wouldn't even be concerned about all these other issues. But when they say that they want employers to look at recidivism studies, they're almost asking you to become social scientists. And when the social scientists don't agree on what works, I'm not sure how employers are supposed to. But then they also want you to look at the nature of the job and how these jobs tie back to the kinds of offenses you're concerned about. It's all pretty straightforward stuff generally, and most employers have been doing this stuff for 20 years or 30 years. Then there's this idea of individualized assessment. And we've always kind of had this idea that we look at the whole applicant whenever we can, whenever it's not an obvious disqualification based on a certain kind of criminal offense. We look at the whole applicant and the rest of the applicant pool, and we compare them and say, okay, I've got these two candidates, and this one has a clean criminal history, and this one has a fairly recent offense that causes me concern. I'm going to go with the guy with a clean background check, all other things being equal. Well, individualized assessment, though, goes beyond that. The way the EEOC is laid out individualized assessment is that An employer should inform the applicant that he or she may be excluded from employment based on the company's criminal history policy, and then gives the individual an opportunity to explain why the company policy shouldn't apply to them. Okay, so, and there's going to be certainly there are going to be times where you'll want to discuss the details of somebody's criminal history to really understand what happened, and then go try to verify it with your background screening partner. But there are going to be plenty of times where you see somebody has a 2-year-old sexual assault offense. Well, you know, I don't need to have any other conversation with him in my environment to know that this is not a person who's going to be a good fit for the jobs in my area. Or if you're in patient care, or if you're working in child care, or you're working with vulnerable populations, there are a variety of offenses that would disqualify somebody from ever working in that area. I speak to former offender groups from time to time to help former offenders apply for work and with a background, but how do we address that with former employers, those kinds of things. And I had a while back somebody come up and say, well, I used to be a human resources director. Do you think I'll ever be able, with I've got a felony conviction, do you think I'll ever be able to get a job in HR again? And I said, well, what's your felony for? And he hemmed and hawed and ultimately told me it was sexual assault of a child. And I told him, no, I don't think any employer in their right mind would ever hire someone with sexual assault of a child conviction as their HR director. Because think about this, if you're going to hire someone to be your HR director, they're going to have to do investigations. They're going to have to deal with employee relations issues. They may even have to counsel with employees one-on-one. But as soon as there's a lawsuit claiming that an investigation wasn't performed correctly, or that this person had a bias or anything like that, and you have to put this HR director on the stand to defend the company and demonstrate that he operated fairly and competently, the first thing they're going to bring up or try to bring up, the other side is going to say, hey, look at this guy's history. He's a child molester. He's a sex offender. And I just don't, I can't imagine a situation where an employer would be willing to put somebody in a role like that. There's certain roles that have trust and certain offenses that negate that ability to put the company's trust in an individual for certain roles. And so having this kind of conversation with them under individualized assessment, you would have to sit down with the HR director applicant and have that conversation with them. Say, give them an opportunity to tell you why your policy should not apply to them. And if you do a lot of hiring, you've got a good criminal history guideline sheet that tells you what's acceptable and what's not for certain kinds of offenses. Do you really have the time to spend talking to all these candidates who are disqualified? That's what they want you to do. So what kind of information might the applicant give you that would tend to show you that maybe you need to reconsider your policy with regard to them? Well, their side of the story, the facts or circumstances surrounding the offense. And believe me, we talk to applicants all the time, and I've heard some pretty interesting stories over the years about what happened. The cop had it in for me, or there's always some excuse as to how that person found themselves in this predicament. But really, as an employer, are you qualified to evaluate that? The number of offenses for which the individual is convicted, and yeah, I think that is definitely something you want to look at. There are certain, probably, there are certain offenses you don't care about that aren't directly related to the job, but you see a series of them, and it makes you begin to question the judgment and the behavior, maybe the safety performance of this individual, even though you weren't. If it was just a single offense, you wouldn't be concerned about it. older age at the time of conviction or when they're released from prison. Basically, the older you are, the less likely you are to commit new offenses, or at least, as you know, some people have suggested the older you are, the less likely you are to get caught committing offenses. You're a little older and wiser. But they suggest that's something to look at. What kind of work did you do, did the individual do after their conviction, and what's their work history been like? That's always something good to look at. But there are times where an employee may not have enough of that to justify making an exception to your policy. What their employment history was before and after the offense. I love this one, rehabilitation efforts. And maybe, I'm sure a lot of you, I've got about 80 people I think on the line, a lot of you are smarter than me, but I'm not sure that I would be able to look at certificates that someone got while they were in prison. They took this class, or they took anger management classes, or they took Microsoft Word classes and all that, and tell you whether those programs were successful in rehabilitating this person. The criminal justice system has spent a ton of money, over millions and millions of dollars over the years trying to figure out how to rehabilitate people, and clearly they haven't figured it out. Employment and character references, and now all character references really are intelligence tests. Is this person smart enough to list 3 people who are going to say nice things about them? But do you really care that this person's preacher says nice things about them? What's he going to say? Employment references, if you've talked to previous employers and they say that he's great, that may be helpful. But character references, I'm not sure that you want to get into evaluating those. And then whether the individual's bonded under a federal, state, or local bonding program. And these are programs that basically insure the employer against loss if the individual does something illegal and causes a loss for the employer. Of course, if you ever have to collect on that insurance, it's too late anyway. And I don't think that any of us would ever go into a hiring decision saying, yeah, I'll hire them, and if it goes wrong, at least I'm insured. That's not, I think we're a lot more concerned about the safety of our employees and the public and protecting our assets. So here's some serious gospel according to Coffey about how you might respond to the EEOC's guidance, especially with regard to individualized assessment. If you've got a criminal history inquiry, whether it's on your employment application or in a later document in your process, where you inquire about the individual's criminal history, add a statement to that, because you always want to have your applicants write down their criminal history. Make them really commit to what their history is, and then add this section that tells them, that basically does the individualized assessment right up front. You've told me about your criminal history. If there's additional information that doesn't tell the full story, or if you think there's information that would help us better understand the context of that, please provide that information right here. So that way you're doing it right up front, and you're not waiting till down the road when you're looking at, you've decided you're going to hire this applicant. Maybe you're in HR and you've already referred the applicant to hiring managers, so now your credibility is tied up in it, and then you're going to have the discussion about criminal history and whether the policy makes sense or not. Why not just have them commit to their story right up front, either on the employment application or at a later point in the process, and then tell you their side of the story, do the individualized assessment on paper so that it's in black and white. So what if you don't have that inquiry, you run the background check, and now the criminal history information comes back on the background check? Well, under the Fair Credit Reporting Act, and we've got a whole webinar on FCRA, but and the FCRA requires you, before you take adverse action based on information in a background check, a consumer report, you have to give the individual a copy of their rights and a copy of their report. So why not, in the notice where you give them a copy of their rights and their report, go ahead and add language that says, again, if you think there's additional information that would help us better understand the context of all this information, please provide that to us immediately. So give them, again, an opportunity right up front inside of your FCRA disclosure process so that they can tell their side of the story, and you don't have to sit down across the desk from them and have these conversations because you don't have time to do it. And quite honestly, you don't necessarily want to have these conversations with some people based on the kinds of offenses they've had. And the EEOC does recognize there are times where if the applicant doesn't provide that individualized assessment information that you requested, you can go ahead and make your decision without it. And we've been actually doing this process for about a year with a number of clients who've built it into their process, and I have yet to have any clients tell me that anybody's ever provided them any individualized assessment information. So I think having to actually write it down and commit to it is harder for people who might otherwise be inclined to shuck and jive you, make up a story about what their history. When they have to actually write it down and commit to it, and then it's something that can maybe go be verified, they're less likely, less interested in trying to fool you. And the EEOC does say that there may be times in limited situations where a very targeted screen, a prohibition for certain offenses for certain kinds of job without individualized assessment may be necessary. They probably want it a lot less than I would suggest you do it for certain jobs, but they do recognize there may be circumstances where that's appropriate. They also say that if you're a federally regulated employer and there's some federal law that says you can't hire, like if you're FDIC insured and you've got banking laws that say that you can't hire anyone with theft or dishonesty convictions, then federal law would trump all of this, because this is, again, just an EEOC policy guidance, and that following federal law is probably a defense to discrimination, disparate impact claim. Following federal law would be. But they do say that if you're following state law and your state's law creates disparate impact in your workplace because you can't hire certain people under state law, then you could get sued. And when we all saw this, when this first came out, my employment law friends, on both sides of the bar, my plaintiff lawyer friends and my employer defense friends, all kind of laughed at it. Nobody, maybe it's just because we're in Texas and we just assumed that nobody's going to be crazy enough to do this. But sure enough, in Cincinnati, a federal court has found that the Cincinnati School District in Cincinnati, Ohio, can be sued for discrimination for following state law that prohibits people with certain offenses from driving school buses. And so the federal courts found that, yeah, you're following state law, and that was what was required by the state law, but you can still be sued for discrimination under Title VII. So it's happening. And they also suggest that employers ban the box, remove the criminal history inquiry from the employment application and move it to a later time in the process. And again, we've got a new webinar in June that's all about criminal history inquiries and what different state laws are out there and how to word them in ways that don't violate different states' laws and still get you as much information as you need. So you may want to attend that webinar. Whatever you do, you want to make sure before you ever start inquiring about criminal history or running background checks that you have your policy in place. I think it's really important that you get expert advice from your background screening partners and from your legal counsel to make sure that your policy makes sense for you. Remember, the whole idea is to figure out how past behavior may predict future on-the-job behavior. So you've got a bomb there on the right and possibly a bomb there on the left as well. So one way a lot of employers are doing this is putting together a criminal records matrix, relevance matrix, and adjudication matrix, but basically says for these particular kinds of jobs, we are concerned about these kinds of offenses. Some offenses, yes, they're completely eligible for hire. If it's a one-off offense, the applicant's honest with us about it, they've got no problem, we will hire them. They're eligible for hire. Some of them go green light, yellow light, red light. Some are just yes, no, or corporate review. But then there are some offenses where there's some corporate review required, where you look at it and you say, you know what, this is a computer crime, say, and let's look at the details. Let's better understand what happened. We're not going to eliminate the applicant from consideration right up front, but we're going to get a full understanding of what happened in that circumstance. Maybe we're going to ask our background screening partner to pull copies for us. We're going to get the full story, and then we'll make a decision, and we'll use this information to compare this candidate to the next candidate and make a decision. And then there are some offenses where the person is just flat not eligible for hire, and that should be pretty limited in how you use it. And what that might look like is something like this, where you've got certain offenses down one side, and then you've got columns for time periods. And in this sample, we use 3 years, 3 to 7 years, or 7+ years. And then some people will be, for this, in this example, alcohol consumption or possession, they're eligible across the board. But auto theft, in the last 7 years, they wouldn't be eligible for employment in this role. But if it's more than 7 years, it's going to be a corporate review. We're just going to look at it and get the full story. Then computer crimes, you can see across the board down there. They're all C's. It doesn't mean it's going to automatically eliminate somebody from consideration, but we're going to look at the details. So that's an example of what that looks like. And we have in May, a webinar just on putting one of these together, how to build a relevance matrix that's appropriate for your organization. This is a sample criminal history question. We're really out of time, and we always have more slides than we have time here. But we will send everybody the presentation. But let me just go through, see if there's anything additional. You're all going to get the notes, and every time I have a discussion with an employer, it ends up adding new slides to this. So there are a lot of slides here for considerations that you'll, just as you write your policy, things for you to think about. I should probably break this into yet another webinar. There's a lot here. Make sure you document everything. You want to make sure that you, whatever you do, the reasons how you put your matrix together and what decisions you make when you're considering somebody's criminal history, make sure that's all documented so that you can show that you had a sound business reason for whatever decisions you made. And the last consideration that I think a lot of employers are waking up to is that you need to treat your contingent workforce, your temp to hire, or even your temporary employees, your staffing agency employees, the same as you do your regular employees. They've often got the same access as your regular employees. Maybe you're hiring contractors, or maybe your IT department's bringing people in to do work for you on your network. And do you run background checks on them? No, we have the agency do the background checks. Well, I promise you, most of those agencies aren't doing a good job on their background checks. And an example of this is this guy on the right, Stephen Robertson. And we've got he's on our Bad Hire Days website, but he has hacked into the networks of 2 previous employers, and he served federal prison time for unauthorized access of a computer system. And now he's a contractor, and if you go find his LinkedIn profile, you'll see he's worked for the city of Dallas, the Dallas Hospital District, and a whole bunch of other organizations, according to his LinkedIn profile, since his federal conviction for computer crimes. So make sure you've got a process in place to do your due diligence on contractors. And that's it. We've got a number of questions, but keep sending me your questions, and I will stick around as long as we need to answer all of your questions. Please keep putting those through. We will be sending the HRCI credit to everyone this afternoon, as well as a link to download the slides, notes, and a link to to watch the video of this presentation. And those are our upcoming webinars. Let me go to these questions real quick. Let's see what we got. how does this apply to the California Education Code when working with children under the age of 18? Well, it depends on what part of which education code requirements you're talking about. And I'll be honest, we do our very best to avoid California clients, and so, and I don't have any California education clients, so I'm not sure of which, what those requirements are, Virginia, or Veronica, I'm sorry. But if you've got, I can tell you that federal law will apparently trump state law as far as what you can and can't consider, but it may be that your state law makes a lot of sense, and that you don't need to worry, to complying with state law. And quite honestly, I think any employer who says that they're going to ignore state law so that they're not found to be in a position where they're discriminating is, and by the EEOC or federal court, is probably making a big mistake, because you're probably a lot more likely to be shut down and put out of business for not following a state licensing or employment regulation than you are from the EEOC, but just pay attention to that. Risk insurance carriers are starting to require employees who have access to cash or check writing to have a credit report run on the employees. What's the best way to respond to the insurance requirement? Well, if insurance is requiring it, what we've seen is that insurance companies are requiring it, but they're not telling you what's acceptable and what's not. And so if the insurance companies aren't giving you the details as to what's acceptable, just run it and put it in the person's confidential file and say you ran it. But I would suggest that if you don't think it's job related, you can run it, but be really limited in how you apply it. If you don't see a job relation, we've got the same issue. We deal with the credit bureaus themselves, and we sell a lot of credit reports. And during a recent audit, they challenged us on the fact that we didn't run credit reports on our clients, and they wanted us to run credit reports on our clients, and I challenged them back as to why, and they said, well, to make sure that they're who you're dealing with, and they couldn't get any more specific than that, and I still don't know what that means, and how a credit report's going to tell me that. We do a lot more due diligence than just a credit report to know who our clients are and verify they're legitimate, but there's this idea out there that credit reports tell you something that I don't think they tell you. But I would run it and just put it in a file and keep your insurance broker happy. Let's see, our company requires security clearances for most of our positions, so it is very difficult for us to hire people with a criminal history. Do we still have to require an individualized assessment? Now, if it's a security clearance that's coming from the federal government, and the federal government says you can't hire the person, then I don't think an individualized assessment would be necessary once the federal government has told you you cannot hire this person. Now, there could be, depending on what clearance you're getting and what government agencies you're dealing with, there may be an appeals process. Some banks, the banks have that, a process available to the individual. So if the individual feels like that they're not being treated fairly, or that they shouldn't be eliminated from employment by the in a bank by the federal government because of their rule, they can appeal it. And there have been some cases where Wells Fargo and some other large banks have kind of been embarrassed publicly because they could not, under the law, hire these individuals because of 25-year-old shoplifting offenses and dumb offenses, but the law said that they can't hire them, and it's federal regulation. So, and then the applicant, it's up to the individual to go and get a variance from the federal agency. So you may make sure, if there is a opportunity for those individuals to get a variance from the government, that you go ahead and make that connection between your candidate and the right authority to consider their request for a variance, and that may be helpful to you in staffing. It's good to see you, Tara, by the way. And that is our last question. If you have any other questions, feel free to email me. You'll be getting an email from me directly here with regard to the HRCI information and all the other stuff I promised. And of course, if your relationship with your background screening partner doesn't make you feel warm and fuzzy that you're hiring the right people, that you're creating a safe and productive workforce, or if maybe your background screening company's been acquired and been subject to mergers and things, and maybe the customer service has gone to hell in a handbasket, which has happened a lot lately, we might be the right background screening company for you, and I would love to visit with you. Please don't hesitate to call me or email me if there's any way that we can help you examine your current process, or maybe improve the information that you're getting. So with that said, I'm Mike Coffey, President of Imperative Information Group. I hope to talk to each one of you at some point in the future, and hope to see you in a future webinar. Thanks a lot for joining us.